Greetings of the day everyone. I Ayushi Jain working as a legal intern in LEXIS and Company. Today in this video I am giving you an overview of General Anti-Avoidance Rule GAAR. Parliament by Finance Act 2012 inserted Chapter 10A under Income Tax Act 1961 which provide a General Avoidance Rule GAAR to be applied from 1st April 2012. However, the protects from industry which fear arbitrage use of power by tax officer force the government to defer its implication and to constitute an expert committee under the chairmanship of Dr. Parthu Saraswati Somi to frame guidelines for GAAR after the consultation with all the stakeholders. Following the report of Dr. Somi, committee various amendments were carried out under the tax law and clarification were provided by CBDT through issue of circular. With effect from April 1, 2017, GAAR has finally become effective. An attempt has made to disappear the complicated provision of the Act dealing with GAAR, tax avoidance, tax planning and tax avoidance, although legal way to reduce taxes, are separated by a very thin line which at a time is indistinguishable. While tax planning involves minimizing tax outgo by use of fiscal incentives available under tax legislations. Tax avoidance, on the other hand, involves arranging the affairs predominantly mainly to obtain tax advantages without breaching the law. It involves a legal exploitation of tax laws to one's own advantages. Taxpayers consider it their legitimate right to arrange their affair in a manner as to pay the least tax possible. However, tax authority internationally considered aggressive tax planning scheme by taxpayer as clever device to evade taxes. GAAR applicability. Section 95 of the Act is basic section that provide for declaring an arrangement entered into by a taxpayer as an imperceivable avoidance arrangement. It may be noted that Section 95 of the Act overrules the entire section and shall have operation notwithstanding contained in the Act. Even the case where the relief is available under double taxation avoidance agreement, the taxpayer will still be continued by the provision of GAAR by virtue of Section 90 Clause 2A of the Act. Further clarified that anti-abuse of in tax treaties may not be sufficient to address all the tax avoidance strategies and the same are required to be tackled through domestic and anti-avoidance rules. If a case of avoidance is sufficiently addressed by limited of business LOB in the treaty, there shall be an occasion to evoke GAAR. Rule 10U of Income Tax Rule 1962 restrict applicability of GAAR only in case where tax benefit in the relevant assessment year arising in aggregate of all the parties to the arrangement does not exceed sum of rupees 3 crores. Now let us discuss what is imperceivable avoidance agreement. The phrase impermissible avoidance agreement has been defined under Section 96 Clause 1 of the Act. For a transaction to be declared impermissible avoidance agreement, it must be satisfied two conditions cumulatively. First condition, the main purpose of the arrangement is to obtain a tax benefit. Main purpose tax. Condition second, the arrangement should have one or more mentioned specified tenant element. Tenant element test. First, arrangement create a right or obligation which are not ordinarily created between person dealing with arm's hand. B. The arrangement result directly or indirectly in the misuse or abuse of provision of the Act. C. The arrangement lack commercial substance or is deemed to lack commercial substance under Section 97 of the Act in whole or in a part. D. The arrangement is entered into or carried out by means or in a manner which are not ordinarily employed or bona fide purpose. Section 96, Clause 2 of the Act make a rebuttable presumption that an arrangement be presumed to have been entered for main purpose of obtaining tax benefit, where main purpose of even a single step or a part of that arrangement is to obtain a tax benefit, notwithstanding the fact that main purpose whole arrangement is not to obtain tax benefit. Thank you.